Yo, it's JP. If you are in the state of Florida and you are about to file a charge of discrimination, retaliation, sexual harassment, etc., watch this video because I'm going to give you some critically important advice. In every state, including Florida, before you can pursue a lawsuit on these types of claims, you are first required to file a charge of discrimination. In Florida, you can either file that with the EEOC or you can file it with the Florida Commission on Human Relations, okay? And it works like that throughout the country. You can either file with the EEOC or you can file with the relevant state agency. In some states and jurisdictions, there might be advantages to filing with the state agency as opposed to the EEOC. But that's not Florida. If you were in Florida, file with the EEOC. Do not file with the Florida Commission on Human Relations. Again, file with the EEOC. Do not ever file with the Florida Commission on Human Relations. And here's why. The Florida Commission on Human Relations can actually issue a finding of no probable cause. And if they issue a finding of no probable cause, that means you're not allowed to pursue your Florida FCRA statutory discrimination claims in court. You can't. Gone. Done. You have to pursue those claims through an administrative process, which is conducted by the Florida Commission on Human Relations. Okay? That's one. That means you don't get a jury trial. So if you could have gotten a jury trial, but you go that route, you can't get a jury trial on those claims anymore. It's gone. Two, even if Florida does not issue you a finding of no probable cause, if they issue you what is the equivalent of a right to sue notice, that will contain two options. The first option is you can file a lawsuit in court. The second option is you can pursue an administrative procedure through the Florida Commission on Human Relations. Oh, and by the way, here's a blank petition. And you can just fill this out and send it back to us. And then you're in the administrative process. But that means you can't go to court. Okay? That option tree right there, where they say you can go to court or you can fill out this blank petition and just send it back to us. And then you're in the administrative process. That's a funnel. Okay? That is designed to funnel you away from court and into the administrative process where there is no jury, where whatever claims you have under the FCRA, the Florida Civil Rights Act, are going to be worth a tiny fraction of what those claims would have been worth in court in front of a jury. And that is all by design, okay? There are some very good folks working for the state of Florida, for various Florida state agencies. I've encountered a number of these folks, and they're wonderful. But at the end of the day, the system, the structure, the processes that are in place in Florida are designed to serve and protect the power structure. And that makes sense. You think about it. Florida's the Deep South. Florida's the Confederacy. Florida's a slave state. Florida's anti-labor. Florida's anti-worker. Okay? And it follows from there that the official machinery, the apparatus of the state of Florida is going to be all of those things. It is going to mirror all of those things. It is going to protect all of the interests that are aligned with that. So the Florida administrative process, going through the Florida Commission on Human Relations, going into their administrative process for resolving your claims, that is designed to benefit the power structure, corporate America, the defendants, insurance companies, etc. It is not designed to be advantageous for the plaintiff or for the employee, okay? It's a tool of the power structure. So number one, you never file with the Florida Commission on Human Relations. You file with the EEOC. You file with the EEOC, you're going to get your right to sue letter, and then you can go to court. You do not ever file with the Florida Commission on Human Relations. And if you made the mistake of filing with the Florida Commission on Human Relations, there's a chance they'll say no probable cause, and then you're screwed, and you just got to go through their administrative process. But if you do get what is the equivalent of a right to sue letter, which has those options where it says option one, you can go to court, or option two, you can go into the administrative process. Don't be tricked by the administrative process. Don't be fooled into thinking, oh, this looks so easy and I don't even need to get a lawyer and I don't have to pay a court filing fee and I can just fill out this petition that they give me. Why do you think they gave you a blank petition and we're like, hey, if you want, you can just fill out this petition and go into the administrative process? Power structure tool funnel. That's what that is. That's what that is. That's the advice for today, okay? As a side note, the reason why I provide specific instructions like this and I talk about these very nuanced issues is because there are so many folks out there who simply cannot get a lawyer, okay? And there are two critical reasons why folks, particularly in the South, particularly in Florida, cannot find a lawyer for these types of cases, okay? And I know because my office gets hundreds of phone calls, emails, text messages, inquiries, etc. on these types of cases every week. And every single week, there are 30, 40, 50 people who have called countless lawyers and they can't get a lawyer for their case, all right? And here are the two biggest reasons why they can't get a lawyer. One, they can't get a lawyer because of judicial activism, okay? Judicial activism, right? It's a bad word in the practice of law, but it's a very real thing, okay? Federal trial courts in the South, particularly throughout the state of Florida, have spent the past 20 or 30 years granting summary judgment in employment discrimination cases at a ridiculous clip, okay? They are granting summary judgment. They have been granting summary judgment in many cases where the case should have gone to trial. They're doing this in violation of Rule 56, which is the rule governing summary judgment. Basically, a trial court is not allowed to grant summary judgment unless there is no dispute of material facts, right? Like if any of the material facts are in dispute, then the case is supposed to go to trial. But the federal trial courts in the South, and particularly in Florida, have not been abiding Rule 56. They have simply been setting aside Rule 56, and it's like, well, I don't like the case, so summary judgment granted, right? There have been all these artificial barriers and obstacles and hoops set up, which have nothing to do with Rule 56. It's a wild emperor has no clothes moment in the legal system and in society. And the 11th Circuit Court of Appeals is entirely aware of this, and in fact is trying to correct it and has issued a number of orders over the past few years telling the federal trial courts in the 11th Circuit, look, you have to apply Rule 56. And the interesting thing there is that it's not, liberal judges on the 11th Circuit who are coming down this way. It's everybody, right? Including very conservative judges who are like, look, follow the rule. Rule 56 says what it says. You have to follow the rule. The rule applies in every single case. But in practice, in the trial courts, they haven't been doing that, okay? So because the trial courts have been improvidently granting summary judgment in so many of these cases, a lot of lawyers simply aren't willing to pursue these cases, okay? Many of these lawyers are not willing to go the distance. They're not willing to file a case, litigate it, do discovery, take depositions, go to summary judgment, brief summary judgment. And a bunch of lawyers aren't even willing to file a case. They're just not willing to go to court. We get calls every week from folks who have legitimate cases. I'm talking about real cases, cases that you put in front of me and I size it up and I say, that's worth $250,000, $300,000. Definitely, that's worth at least $250,000, $300,000. These are real serious cases. And other lawyers are like, no, I won't even file it because it's just too much of an uphill battle. Their trial courts are granting summary judgment too frequently. They're getting the law wrong, and I'm not going to do that and have to go to an appeal, and I don't even do appeals, and it costs time and money, and it's not worth the squeeze. And on the flip side, the federal courts over the past, 15 years in particular, have applied tremendous downward pressure on the attorney's fees that plaintiff side employment lawyers can get in civil rights cases like this. Okay? Used to be a time in the 80s and 90s and even into the early 2000s where trial courts would look at cases like this, civil rights cases, and if the plaintiff prevailed, they would basically say, hey, this is an uphill battle type case. It's not very attractive business. The plaintiff's lawyer took it on a contingency fee. We're going to figure out what is the reasonable rate for a good experienced lawyer in the marketplace, and then we're going to double it. So if the rate is $400, it's kind of a normal rate in this market. We're going to give this lawyer who took this civil rights case on a contingency fee and took all of this risk in an uphill battle, we're going to give them $800 an hour. Okay, and that's how the law was supposed to work, and that incentivized good lawyers to take these types of cases. But all of that stuff stopped courtesy of Justice Samuel Alito, right? Flying his upside down rebel flag outside of his beach house. But no, he's not a nakedly political actor. Yes, one Samuel Alito in the Supreme Court decision called Purdue, where Justice Alito was up in arms over, you can't have these small-time lawyers getting multipliers and making as much per hour as the biggest, most prestigious firms in America, right? Well, actually, you could. You could and you should if you wanted to incentivize good lawyers to do righteous cases that are an uphill battle. But clearly, Justice Alito didn't want to incentivize that. And then, he got a majority on Purdue, and then they changed how they do Lodestar fee awards. But guess what, hombre? I'm about to blow Lodestar up, okay, with what I'm working on. As some folks know, I'm working on my own LLM, okay? I'm working on what is effectively Pollard Synth. It's going to be a synthetic JP legal brain that can basically do 60-70% of whatever I can do. So it can write, complaints and summary judgment briefing and stuff like that. And people are like, oh yeah, doesn't stuff like that already exist? Stuff like that exists, and it's trained on bums, okay? JP Synth is training on my own proprietary in-house data set that goes back 13 years, right, of all the firm's data. Plus, I'm the one testing it and fine-tuning it, okay? So at some point, JP Synth will be able to do, 60-70% of all this work, and it'll massively cut the hours that we spend on these cases. So I'll be able to run thousands of cases, and then I'll be able to go into court, and they'll start talking about this old-timey Lodestar, hourly rate, whatever, and I'll be like, bro, I spent X millions of dollars in time and money developing JP Synth to do this work. So you can't Lodestar me. You got to find out some other way to award me fees for this work I'm doing. And it has nothing to do with the hourly rate in the market, whatever. But that's a whole nother tangent. That's a whole nother issue. Okay. But suffice to say, courts are suppressing the fees that attorneys can get who pursue these types of cases. And so now it's a double-edged sword. Now you have two disincentives. One, you have the disincentive of it's an uphill battle and courts are incorrectly granting summary judgment and not correctly applying Rule 56. And then you have the fact that they're whacking down your fees, which means that nobody wants to take these cases, which is entirely borne out by what I see every single day. When folks call our office, and they report that they have called 5, 10, 15 lawyers and that nobody was willing to take their case. In fact, I spoke with the lady yesterday, okay? And I don't speak with any of these people, but I spoke with this lady in particular, because we already represent a woman, she's a client of the firm, and it's a sexual harassment, sexual assault case, arises out of a certain company. And one of her coworkers who had previously left the company had experienced the same thing, right? She was sexually harassed, she was sexually assaulted by the same perp at the same company. And the company's outside lawyers had just reached out to the friend and said, hey, you want to settle? We can work something out, right? She doesn't have a lawyer, okay? And so she's freaking out. She doesn't know what to do. And so she reaches out to her friend, who's my client. And my client says, JP, she's in this situation. Can you help her? And so my first question was like, is she legit? And my client says, yeah, she's legit. She's really nice, And I said, great, give her my number. I'll talk with her. So I talked to her. She called around. She called several different law firms. She couldn't find a lawyer. She has a real case. She has a serious as fuck real case. And she couldn't find a lawyer, And people look at that and they think, oh, that's unfortunate. It's a problem. No. That's by design. That's by design. That's the system working perfectly. That's exactly what the power structure wants, like especially in places like Florida, right? Slave state, confederacy, anti-worker, anti-labor. That is what Florida wants. The power structure, right? The powers that be. That's what they want, okay? They don't want people having access to counsel. They certainly don't want to incentivize capable, qualified lawyers to take cases like this. And that's why so many folks can't find a lawyer, okay? And I know that's a problem, all right? And I'm working on other ways of attacking that problem. I know I do my YouTube videos. I try to give people as much advice as I can, steer people straight, give people some tools in the toolkit. But I promise you folks, I'm going to do even more than this. I'm working on overhauling my website. And we're going to have a whole section of the website called resources. We have a section right now, but it's going to be beefed up tremendously. The resources area of the website is going to have case law, templates, templates in Word document that you can download and you can edit. I'm going to have templates for all sorts of cases. I'm going to have templates for 42 USC 1981, Title VII, FCRA. I'm going to have templates for federal court, state court, unpaid wages, FMLA, the list goes on and on. I'm going to have a whole bunch of templates, a whole bunch of case law, and I'm going to have a whole bunch of PDF guidebooks on how you put these things together. And when I get JP Synth built, when I get my AI product built, I might find some way to integrate a piece of that into the resources section. But I'm about it, folks, right? A lot of people might hate me, but they can't say that I don't go out there and do what I believe in. Democracy is coming to the USA. Happy Friday.